Thank you for joining us today for a Public Records Act training. Today we will discuss RCW 4256, again known as the Public Records Act or the PRA. Today's training will feature the following team members of the King County Public Records Program. You will hear from Thomas Barrington, Rachel Miles, Crystal Mua, Stephanie Santos, me, Shelby Michelton, and we'll start out with Joel Wade.
Thank you, Shelby. The Public Records Act, or PRA, was created to provide the people with broad rights of access to public records. The PRA states that it must be liberally construed to promote the public policy of open government. We, as public employees, don't have the right or ability to decide what is good for our citizens to know. The PRA is here to help guide us. Courts interpret the PRA liberally in favor of disclosure, the reason being that doing so helps promote government accountability. So whose records are they? We are the custodians of so many different types of records, but are they actually our personal work records? No. All our records are owned by the citizens of Washington State. To ensure they remain the property of the state of Washington, we all have a duty to preserve, store, and dispose of our records in a proper manner. So what is a public record? A public record is any writing that relates to the conduct of governmental function. And while that sounds simple and concise, it doesn't just include records that we ourselves personally create throughout our typical workday. If it's a document that we use or kept while conducting or performing our jobs, even if not created by us directly, it is still a public record and must be preserved appropriately. While a record is defined using the word writing, it's not quite as simple as that. The word writing applies to handwriting, electronic documents, printed documents, photographs, and many other record types, as you can see currently listed on the screen in front of you. So we now know that a public record is basically anything that we create or use to conduct our work. This could be files that we generate on our computer during a normal workday, or a voicemail we leave for a coworker. You probably work with a wide variety of records on a daily basis, like emails, Word documents, Microsoft Teams chats, or entire databases. If you ever have questions about whether or not something is a public record, any of us in the Public Records Program are happy to help you out anytime.
So how do you recognize a public records request? Public records requests do not have to be in writing. So anytime you see or hear something along the lines of the following words, acronyms, or similar phrases, that should trigger in your mind to consider that the person is making a public records request. So that's public records request, PRR, PDR, FOIA requests, and also be aware of hidden requests that may be a small request that is in a larger document. So what are the legal requirements in response to a public records request? Agencies are required to promptly make available for inspection and copying all identifiable public records unless the record falls within the specific exemptions of the Act or another statute. Agencies were required to provide the fullest assistance to requesters. Also, we must provide an adequate search. If we think records will be in a location, we have to search that location. And if we find out that there are other locations where records may be in the course of our search, we have to also go to those other locations to search for records. We are also required to provide a response in writing within 5 business days. In this 5-day response, it must provide for inspection or a copy of the records requested, provide an internet link to our agency's website, must acknowledge that we've received the requests and provide a reasonable time when we would be responding to them. If we need clarification, we will have to seek clarification. And if the request would be a denial in accordance with law, then a written statement must be accompanying the denial with the specific reason that we've made the denial. So what does the PRA not require us to do? Agencies are not required to create records or respond to requests for information or explain records. There may be times when these will be in our interest to do, but those you can speak with your PIO or your agency's leaders. You can probably scratch that last part in this recording, please. The PRA also does not require requesters to state their reason for the request. An exception to this would be if the request is for a list of individuals for a commercial purpose. And a commercial purpose means the person requesting the records intends that the records will be used for any business activity by any form of business enterprise intended to generate revenue or financial benefit. The PRA does not require requesters to provide their names. The exception being if a request is for records that is only available to certain individuals, such as a person's own medical records or autopsy reports that are available to family members. So what are the legal requirements of you? You are a steward of the public records. Every record that you create or use to conduct county business is subject to the requirements of the Public Records Act. If you receive a request, make sure to inform your public records officer as soon as possible so that they are able to provide the response within the 5-day window. Additionally, when you are contacted by your public records officer with a request, please ensure that you read the request immediately. If you're aware of other employees or agencies who may have records, please let your public records officer know that. Conduct a thorough search of your records and provide all the records to your public records officer. If you think that there's a record that can be legally withheld, or another records custodian may have that same record, please also provide those to your public records officer so that each record can be properly accounted for. It is your pro's responsibility to review and apply any exemptions, withhold, or redact. You can definitely alert your pro to any concerns you may have about certain records if you suspect that there might have sensitive information or information that would need to be redacted. Please know that it's illegal to destroy public records, even if you find them to be inflammatory or embarrassing.
Next, we'll be talking about best practices around using county resources for personal use and using your personal devices and accounts to conduct county business. It is best practice to only use county resources to conduct county business. To name a few examples, your laptop or machine, your email account, and the county issued devices such as cell phones. If you happen to send an email using your county email account and you included personal information, the record can be considered a public record. The example shown here includes an employee's home address. Another best practice is to not send email messages that you would not want forwarded to your supervisors, the public, or posted in a public forum because records can be shared without your knowledge or consent. It is best practice to not use your personal devices or accounts to conduct county business because if you do, the records you create to conduct county business are considered public record. For personal devices, a few examples we've listed here include phones, tablets, and computers. Email accounts and social media accounts like Facebook and Twitter are considered personal accounts. Records custodians are required to provide all responsive public records from personal devices and accounts. The key takeaway here is to refrain from using personal devices or accounts to conduct county business. It is best to keep work and personal matters separate. Next, we'll dive into exemptions.
Let's talk about exemptions, which is one of the legal requirements of state and local agencies. State and local agencies are required to disclose their records upon request, unless a record falls within a specific exemption or exemptions. Where can we find these exemptions? Well, a lot of what we use as exemptions for public records requests on a daily basis are found in the Public Records Act, which is RCW 4256. but there are also other state and federal statutes where we derived exemptions from. Some of them, just to name a few examples, include mediation records, privileged materials, which we will discuss shortly here, HIPAA privacy rules, as well as food stamp applicants and recipients. So what if I redact or withhold a record for disclosure? Well, an agency must provide a requester with a withholding index, or what we call an exemption log, which details all the records redacted or withheld, describing the record and stating the exemption and how that particular exemption applies. A word on exemption. As we discussed in earlier slides, if a public records request must be liberally construed in favor of disclosure, the opposite applies to exemptions, because exemptions, on the other hand, are narrowly construed to assure that the public interest in full disclosure of public information will be protected. What does narrowly construed mean? Courts have said that if a portion of a document is exempt, the responding agency may redact only that portion, but must release the remainder of the document. We're going to delve into three of the more commonly used exemption, beginning with the attorney-client privilege. Attorney-client privilege means communication between either an attorney and a client to obtain or provide legal advice, communication between an attorney and client regarding litigation or anticipation of litigation. It could be also communication between attorneys regarding litigation, as well as communication between attorneys regarding client advice. Now, the client must intend the communication to be confidential. What does that mean? It means that not intended to disclose the communicated information to outsiders, and person reasonably believes that no outsider will hear the contents of that statement. It is important to read the record in its entirety and not just base it on who is on the header, who's the recipient. Having an attorney on the recipient, the sender, or even CC doesn't make it exempt automatically. If you're unsure whether a particular document falls within this particular exemption, you can always ask a fellow public records officer. You can reach out to the public records group, or worst case scenario, we could always reach out to the King County Prosecuting Attorney's Office for guidance. Now we go with personal records. These are information and files maintained for public officials and employees. They may be withheld to the extent that disclosure would violate their right for privacy. Now, for this exemption to apply, the record must be in the personal files or an employment-related records. This is a broad definition, meaning personal file or personal record carries a broad definition, and it requires a record-by-record review. This particular deck contains two exemptions that we commonly use. One of them is application for public employment. These are exempt from disclosure, meaning applications, resumes, other related materials with respect to the applicant. Why so? This exemption is used to redact the names of unsuccessful candidates from other recruitment records. This exemption is based on the privacy interests of the applicants that were not hired. This particular privacy interest does not apply to the successful candidates, but their resume and application materials are still exempt. The second example here is personal identifying information for the employee. And this may include, among other things, home address, phone, email, social security, information on your dependents, emergency contact information, and so on. Again, for this particular exemption to be applicable, it must be in a file or an employment-related record. Finally, it's the deliberative process exemption, meaning this exemption allows non-disclosure of intra-agency deliberative materials. What are deliberative materials? These are preliminary drafts, proposed bargaining agreements, memos where opinions are expressed or policies are recommended. All these are exempt. The exemption, however, does not apply if the matters on matters that are factual. It does not apply if materials concerning the implementation of the policy. Deliberative materials are exempt only until the policies and recommendation contained in such records are implemented. The reason for that, the court said, this is to protect the give and take of the deliberations that are necessary for an agency's decision-making and to formulate agency policy. It is also to safeguard this free exchange of ideas, recommendation, and opinions prior to making a decision. There is a test given by this case, Pause versus University of Washington, that you can use to determine whether this particular exemption applies. First, the records contain a pre-decisional opinion and recommendation. Second would be disclosure would disrupt the consultative process. Third, disclosure would deter the flow of recommendation or opinions. And finally, materials reflect policy recommendation, not raw or factual data in which a decision is based.
Risks associated with the failure to comply with the Public Records Act. Historically, when talking about risks associated with the Public Records Act, we most commonly talk about financial and compliance risks. In Washington, a strict liability standard is generally applied, which means regardless of intent, we may be liable and held accountable for any violations. However, King County is moving towards a different model where we consider value alongside potential risks. King County is willing to take on more risk as it pursues opportunities to achieve its mission and objectives. The county has created a risk appetite statement to assist county decision makers to help understand risks and value alignment. This risk appetite statement is to help inform how to assess and respond to risks. It articulates our willingness to accept risk when making decisions regarding the 8 key risk areas, which are equity, health and safety, strategy, operations, workforce, finance, reputation, and compliance. We may be willing to accept or mitigate risk when the value is optimized in one of the other areas. Decision makers should consult their agency risk appetite statement and leadership for guidance, or reach out to the Office of Risk Management Services for information.
So now we are going to touch on records management. So all records within the county have a records retention, and those records retention fall on a retention schedule. So what about records with retention value? Records with retention value record county functions and provide evidence of county business transactions. They are needed to provide information about actions related to county projects and activities, and must be available and accessible for at least the full length of their retention period. Records are retained based on the content of a record, not the type of a record. So what is a transitory record? A transitory record has a short or no retention period. It may be in the form of drafts or notes, and these records are not needed to document decisions or actions of county offices. They're not required for legal, fiscal, historical, or administrative purposes. But if a transitory record still exists at the time of litigation or a public records request and they have not been destroyed, they may no longer be destroyed because they are now subject to that litigation or that public records request, and their retention schedule is then frozen. Thank you for attending this training today. Every county department and agency has a public records officer and other public records staff with expertise. Please ask your supervisor for more information about who those folks are in your organization, or reach out to our program for more questions. You can always contact us at the contact information below, and we would be happy to chat with you about any public records questions you may have. Thank you again for your attention.